Hearing Board. We have on the agenda today 3 items. The first 2 are on consent. The first one is Shadow Wolf Energy. Do I need to restart? Okay. Today is Thursday, January 25th, 2024. This is the South Coast AQMD Hearing Board. We have 3 items on the agenda today. The first 2 are on consent, that of Shadow Wolf Energy, case number 6244-2. And the second one is South Coast AQMD versus SCE, Pebbly Beach Generating Station, case number 1262-115. And the third one will be a regular hearing for an interim variance, and that's City of Pasadena Water and Power Department 22, case number 2244-36, which will take third right after the consent. So let's start with the marking of the exhibits for Shadow Wolf. Okay. Okay, I have, and correct me if I'm wrong, Madam Clerk. Okay, the stipulation as B, as in boy. The declaration from Zachary Onstad as number 2. And the proposed findings and decision of the hearing board as C, as in Charlie. Yes. So that was the number for? Yes, which I gave them for, I gave them for the declaration, I gave them number 2. Right, but the proposed should be theirs? Yeah. Okay, all right, then that'll be number 3. Thank you for the correction, Madam Clerk. Okay, they originally came to us, and they've already had a hearing originally. I believe it was for, and was it an interim hearing that we had originally with them? Yes, and so they have reached an agreement with the district. So they have stipulated on here, they had the excess emissions calculation was missing on the last one. And we did grant the interim variance for them. And the regular variance, which is what was for today, that is also stipulated by both parties. So were there any other comments in regards to that case? I know Mr. Belagopulan, you had some questions originally.
I didn't have any questions. I mean, we did grant them the interim variance
Right.
on December 28th.
Mhm.
And the excess emission is 130 pounds per day of NOx. So that was included before. And I think when they came, initially it was turbine 1 and turbine 2, but they removed turbine
Correct.
2 from consideration. So the relief is only for turbine 1, as was granted
Mhm.
during the interim variance. So turbine 2 is not included.
Correct.
Then the reasons is because they are unable to get the catalyst. They initially they ordered the catalyst just for NOx, and then they were then told they also need to reduce ammonia slip, so they had to change the catalyst, and so there's delay in getting the catalyst. It won't be received in maybe around March. So they were requesting time to get the catalyst, install it, and then do the testing, the ammonia slip testing and the NOx testing. So they requesting relief through September 1, 2024.
Correct. And they, when they did come in, they were representing themselves, and I know that they were unaware of the process. And so, thank you to the district and to the clerk's office for helping them, walk them through it, actually. So with that, we can entertain a, motion regarding, the 6 findings to go ahead and grant this on consent. Do I have a motion?
Well, I think we have to make the 6 findings first.
Yes, on the 6 findings, they were out of compliance. Let me pull that out here. They were out of compliance, and number 2, a non-compliance of the district rules is due to conditions beyond their reasonable control, which was the case. And also number 3, the closing or taking would be without a corresponding benefit in reducing air contaminants. Number 4, the petitioner for the variance has given consideration to curtailing operations of the source in lieu of obtaining a variance. They did discuss that with us, and it was a matter of they wanted to go forward and go ahead and take care of the equipment and get it going again. During the period of the variance in effect, the petitioner will reduce excess emissions to the maximum extent feasible, and during the period the variance is in effect, the petitioner will monitor or otherwise quantify emission levels from the source, if requested to do so by the district, and report these emission levels to the district pursuant to a schedule established by the district. So with that, I move that we grant the regular variance for Shadow Wolf located at 25121 Sierra Highway in Santa Clarita, zip code 91321. And this is in regards to rules 203B, 1134D3, 2004F1 from the permit condition D 28.1, and 3002C1 from permit condition D 28.1. The equipment is in regards to the natural gas-fired turbine number 1, and we took off which one?
Number 2.
Yeah, we took off number 2. Okay, and this is pursuant to the conditions established by the district, and that as long as they follow those conditions, we will go ahead and honor the granting of that variance.
So moved.
Okay, any discussion on the motion? Mr. Pearman?
Just 2 things. One, just to augment the findings, to point out that they do provide demand. They serve the grid with their power, which is one reason why curtailing seemed to be something we did not want to entertain. Then secondly, in the Exhibit 3, we should strike the attendance of Member Abraham at the hearing.
Yes, that be noted. Thank you very much, Mr. Pearman. Yeah, they do supply electricity to the grid. They are what we call a peaker plant. And so therefore they are an essential business, and it was warranted that in discussions with the district as well as them, that this was the right path to follow. So with that.
I was just going to add, I think you cited the condition 28.1 for 2004 F1 and 3002 C1, but not 203B. So we should include that also for 203B.
I did mention 203.
Yeah, but not that specific condition, that's all.
Oh, the
You
condition
did for the
number
other
20.
two,
Yes,
so
you're right.
that's all. And the excess emission are 130 pounds per day of NOx.
Yes,
But they will have a SEMS to monitor and record their
Correct.
excess emission and pay the fees accordingly.
correct. Okay. Thank you for that.
Madam Chair, I just want to clarify, my so moved was really meant to say second.
Okay. Any other discussion? All right, let's go ahead and take the vote. Mr. Ali?
Aye.
Mr. Pearman?
Aye.
Mr. Balakopoulon?
Yes.
And I also vote aye. So that is unanimous. And it's also noted that Dr. Abraham will not be attending the hearing today. Okay. All right, with that one, we can go to, let's see here. Shadow up, shadow up. We can go to SCE. And with that, let's go ahead and mark the exhibits. And that is case number 1262-115. This was for a status report and a modification on an order of abatement. And we did have a email that was going back and forth between Ms. Reichert and regarding some questions that we had from Mr. Balagopalan. So we'll be marking that as HB1. And then we have the stipulation, which will be Exhibit 6, based on the previous hearing that we had. And then we have the proposed findings, which will be number 7. We have the declarations, and that will be, and correct me if I'm wrong here, Madam Clerk, starting with N as in Nancy. Based on the minute orders, I looked up both of them. So it should be starting with N as in Nancy from Chris Perry. It should be O for Ms. Isabel Shine.
Madam Chair.
Yes.
Mr. Perry and Ms. Shine are district staff members,
Okay.
so those would be exhibits 8 and 9.
8 and 9. Thank you for that correction. Okay. Okay, and then Mr. Zentz, who I know is with Edison, so he would be N. And Nancy. All right. We also have a statement, a long statement from the city of Avalon. And this was from the fire chief for the city of Avalon, Michael Allegria. And it was quite a large document, but that'll be P1. Is that correct, Madam Clerk?
As I know, this was submitted by the respondent, so it would be a respondent exhibit. That
Versus from
means,
the city?
I believe that that was a part of their exhibit, which was the final grid stability study,
Okay,
and that would be O as in Oscar.
okay, thank you for that.
You're referring to this whole document?
Yes,
So
yes.
it's not the fire department per se, that was just one memo, but this
Well,
was grid stability study.
Yes, yes, it was, but the fact that the city was involved in this as well as the fire department, even though they worked very closely with Edison on this, that's why I had marked it on behalf of the public, but that's fine. We can go ahead and put that in as O. All right, and they originally were here, let's see. It's been an ongoing process with that facility that they're trying to bring aboard new generating turbines, but they also are looking at alternative fuel for that particular generation of electricity. So this report, as well as their declaration, has gone to try and go ahead and go down that path, but they're still working on it, and it's been a process, a long process. And hopefully they can get through it sooner rather than later. Any other comments on that?
Yeah,
Mr. Balagopalan?
Yeah, I wanted to add, there's a prohibition in Rule 1135 currently that they cannot install any new diesel ICE after
Correct.
January 1, 2024. And that's, so the holdup, in a sense, is sort of, I don't know if it's going round and round, catch 22 or not, but they, the analysis indicated that, they did all the studies and the modeling that they'll have to install two or three Tier 4 engines, but the prohibition in Rule 1135 prohibits it. So, and the district is proposing to amend this rule. We don't know. I think the email, the declaration we got from Ms. Shine is that sometime in late summer, but either June or August, and we're not sure how the amendment will take place. So, but until the amendment takes place that allows a new engine to be installed, the permits cannot be issued for the engine. So,
Right.
so that's why they're asking to continue this order abatement
Right.
until after the decision is made by the governing board.
Right, and they were also, as I mentioned before, looking into alternative sources to generate electricity, including solar, including wind, including all of the other technologies that they have been part of on other generating stations. So Avalon is quite a unique location, being that it's over on the island of Catalina. So it's been difficult for them to be able to get all of the parts, et cetera, over there, and it's been quite costly. But in any case, they were here for a status report and a modification for the order of abatement. And I don't, do we need to make a motion?
Yeah, we do.
On the
We-
good cause?
Yeah.
Okay, so did somebody want to make the motion?
No, I just would say we should pro forma ask for public comment before we make the motion.
Thank you. Thank you for that. Do you see anybody who has any, their hand raised? Madam Clerk?
Currently, there are no members on Zoom with their hands raised, and there appears to be no members in person or have submitted cards to make comments or testimony.
Thank you. Okay. So with that, I'll entertain a motion for good cause. Okay. I move that Southern California Edison Pebbly Beach Generating Station located at 1 Pebbly Beach Road, Avalon, California 90704, that we find good cause to accept the status report and modification for the order of abatement. This was originally, last time we had them here, I believe was a year ago? My goodness, how time flies. I thought there was a hearing that we had in July. We had a hearing in July on 7/25. So, and that originally was for the order for abatement. But that was also on consent at that time. And this was in regards to Rule 1470C4A. This was regarding the equipment, the diesel internal combustion engine, Unit 15. The device application permit was AN 595-203D42. And the SCE, the Selective Catalytic Reduction System Unit 15, device application permit AN 548965C58, and then the carbon monoxide oxidation catalyst unit, also unit 15, AN 548965C82. So that was also in regards to, I believe, that was it as far as the emissions. Let's see. I don't see anything. Do you have that?
It's an order for abatement.
Yeah, it's an order for abatement. Sorry about that. So anyway, we can go, if we go ahead and find good cause for that, I move that we do so unless there's any other addition to the
Well, I
motion.
think we should refer to the proposed finding a decision document because there are new conditions that have been added also, and we need to remove, as Mr. Peon pointed, Mr. Abraham's name from the document.
Yes,
From the
yes.
finding a decision. So I think should accept the conditions that is in the proposed finding a
For
decision.
stipulated.
And basically, it is asking for more information on the propane system.
If they go that route.
So, but
Okay.
yeah, so I would say yes, as per the condition as per modified in the proposed finding and decision document.
Yes, I accept that amendment. Yes, I accept that amendment to the motion.
And I second the motion.
Okay, any other discussion on the motion? Okay, if not, let's go ahead and vote. Mr. Ali,
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan?
Yes.
And I also vote aye, so that is unanimous. Okay, so now we can go on to the city of Pasadena. This is for an interim variance. This is case number 2244-36. It's in regards to rules 203, 2004, and 3002. And who's here on behalf of the district?
Good morning, Madam Chair. Mary Reichert on behalf of the Executive Officer.
Okay, and on behalf of City of Pasadena?
Good morning. I'm Lisa Hudson, Assistant City Attorney. Oh, sorry about that. Good morning, board members. My name is Lisa Hosey, City of Pasadena, Assistant City Attorney.
Thank you. Okay,
We have Art Silva.
all right.
And I'm Art Silva, Power Plant Manager from the City of Pasadena.
Okay, and do we have exhibits for City of Pasadena?
Did you have any exhibits you'll be presenting?
No, we do not.
Okay,
And the district has submitted to the clerk proposed conditions.
okay. And we're marking that as, let's see, dash. Yeah, I haven't received anything other than, I think we may be getting it now.
I left it on a shelf. Oh, right here, sorry. I was trying to be efficient. There, I just left it there, sorry.
Thank you, though, Ms. Reichert.
And does the parties have that?
Yes.
Okay, and in this case, since it's an interim variance, we will be bifurcating. Thank you.
Thank you so much.
We will be bifurcating the case. The first part will be for good cause. If we can find good cause, then we will go on to the second part of it, where we will take on the 6 findings, and that'll be how the process of the hearing goes. I don't know whether you're familiar with that process, but if not, don't hesitate to ask any questions and or stop and say, you know, I need to understand that a little bit better. We'll go ahead and try and walk you through this if so. Okay, so with that, we will be marking that as exhibit, let's see. What do you have on this one, Madam Clerk?
This is the first exhibit for the respondent, which would be letter A.
Okay, thank you. All right. And will you be having witnesses this morning?
Just the power plant manager.
Okay, and Ms. Reichert, are you going to be having witnesses?
The district does not plan to call any affirmative witnesses, but we do have district staff from compliance as well as engineering if the board has any questions.
Okay, All right, so all of those who are going to be testifying or possibly testifying, if you can please stand and raise your right hand. Okay, do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth? Okay, thank you. All right. Okay,
Can I make a statement?
yes.
I've probably handled 2 or 3 matters over the years for the city of Pasadena, none for this department. The last one probably ended 2 years ago. And maybe in the last a century, Miss Hosey was a law clerk of mine when she was in law school. So I didn't know she was on this case. We even discussed it. I don't feel any of that factor should in any way suggest I would not conduct a fair and impartial hearing, but I leave it up to the parties to make any statement they wish with regard to that.
Thank you, Mr. Pearman. Okay, any objections?
I have no objection.
Okay, and I'm assuming no objections from the city of Pasadena.
I didn't hire her full time. Well, unless it was grant bosses and things like that.
Okay, all right, with that, let's go ahead and start with opening statements, and who will be giving the opening statements on behalf of the city of Pasadena?
I will.
Okay, go ahead, sir. And please state your name and the fact that you've taken the oath.
My
and
name
your
is
position.
Arturo Silva. I am the power plant manager for the city of Pasadena. I have taken the oath today. And what we're here for, I believe, doesn't have much nuance in the way of the matter. The piece of equipment that we are requesting the variance on is broken. It's not working. And therefore we can't perform the required NH3 slip test or RADA until we repair the gas turbine and get it back into service. And we've kind of discovered this in late October, right before the Thanksgiving holiday week. We submitted our variance in December. And now we're here for this interim here.
Okay, Ms. Reichert?
The district is not opposed to a finding of good cause. Thank you.
Okay, you can go ahead and call your first witness.
So I'll continue. So on November 16th, the generating unit device ID D56 tripped for what is a variable bypass valve issue. We did further investigation and we did find evidence of carbon in one of the filters in the lube oil system on the gas turbine. And the what appeared to be metallic particles on the chip detector. We contacted GE, the original equipment manufacturer for this piece of equipment. It is an LM6000 PG. They came out on Monday, the 20th. They did help us with inspection. We did uncover more metallic particles in the lube oil system. They advised us to take those particles and send them to their preferred lab out in Phoenix, which we promptly did. Unfortunately, we never did get results at preferred lab. We sent it to our own lab. We got our results just this week, but we've asked GE and they provided a proposal for the repair. We also reached out to GE's competitors for LM6000 repair, and all of them have declined because it is an LM6000 PG unit, and GE certification that they hold only extends to the PC unit. And everybody's told us that GE is currently the only PG certified repair shop. So we're tied to GE at this point without much choice, and We're gonna obviously repair the unit expeditiously. It is 65 megawatts out of over 200 megawatts that we have for local generation. It will hurt us significantly financial wise in the third quarter due to the resource adequacy requirements that the city has to meet as a load serving entity as part of the CAISO. So our objective obviously is to get this unit in the shop, repaired quickly, and back into service. And of course, once we get it back and it's back up running, we will conduct the necessary testing to once again be in compliance with our permit.
Okay. Did you have any questions for your witness? Ma'am?
No, Madam Chair, thank you.
Thank you. Okay. Ms. Riker?
Thank you. I just wanted to go over the timeline a little bit. When did you decide that you definitely were going to have to pull this out of service and not be able to perform the test?
So we were hoping to get a response from, oddly enough, the outfit is called FAST, the testing company. And not to get into GE's business here in a public forum, but there was some sort of disagreement, financial disagreement between the lab that GE recommended and GE. They wouldn't accept a purchase order. So they never did do the samples. We had to ask FAST to send us the samples back so we could send them to our own lab. And that kind of would have informed us if it was in fact a bearing failure, as the indications are, or if we have some other issue that could be quickly resolved, like the attached lube oil pump perhaps coming apart. And then in that case, that could be done on site, change out the attached lube oil pump, flush the lube oil system, and get the unit back up and running, because the issue then wouldn't be with the unit. But now that we do have samples, it does appear it is bearing material. And of course, we got confirmation yesterday, but we've been moving along at this point, trying to get confirmation of what that material was, but also taking the worst case scenario approach and saying, give us a proposal, we'll get our approvals in place so we can send that unit out.
Okay, so I just wanted to kind of figure out like the timeline. Do you have kind of some dates of when these different things occurred?
So that was November 20th when we pulled the sample
Okay,
with the metal particles.
okay,
We did send that out to FAST that week. They were closed for the Thanksgiving week, the entire week. We didn't hear back from them until the following week. And then over the 2 weeks after that, there was back and forth between GE and them about whether or not they would do the work unless they got paid up front. And eventually, we asked for those samples back in January to send them to our own lab.
oh, you didn't get them back until January.
Yeah.
So when was the determination made that you would not be able to meet the deadline for the testing?
So at the point where we were in that first week of December, it looked pretty apparent to us that we were not going to meet. We were not going to be back up and running by January 1st and would not be able to perform the testing.
Okay,
So then we did contact AQMD staff and let them know that we were going to be filing a variance. And then went through the process of filling out the variance, requesting a check, and getting that variance filed.
and then when did you actually file the variance?
I believe the variance was filed that week before Christmas.
Okay. Okay, no further questions. Thank you.
Okay, thank you, sir. Mr. Silva, are you are you utilizing any other source of generating in place of the 65 megawatt unit?
So the entire plant is a peaker plant. They all seem to run independently of each other. They are Cal ISO participating generator units.
Mhm.
So it's not so much that we've run other units to replace energy from this gas turbine. But for example, we did have it originally scheduled to run for New Year's Day events as system resiliency and, the backup. So the entire nation doesn't see the world will go black. We ran one of our other units instead of
Uh-huh.
gas turbine 5.
Okay, so there was no issue in regards to lack of capacity.
We don't expect there to be an issue with lack of capacity until the summer months, and we'll see how that goes. But again, that's
Are you hoping to get back online before that?
we're still hoping to get a timeline from GE at this point.
Okay, all right, thank you. Any other questions, Mr. Balagopalan?
Well, I do, because we have to establish good cause and whether you were diligent in filing. Your petition said you knew in November 21st, GE recommended not to operate until the repairs were complete. So November 21st, round about there, you knew that you cannot operate it, correct?
That's correct. That November 21st is when we received the recommendation from GE, but we hadn't clarified yet whether it was an actual bearing at that time or whether it was another system component that was causing the metal particle.
So do you have the date, Madam Clerk, when specifically it was date stamped here when it was applied?
Unfortunately, the petition was not date stamped. However, we did receive the petition, and the reason is because I didn't date stamp it. I do have, unfortunately, I have the FedEx email where it was received in our office, December 21st.
December 21st, okay. Now, so one of the findings we have to make is whether you're diligent in filing for the petition. So what was a delay? I mean, you didn't file it till December 21st, and the delay was mainly due to getting the results from the analysis from the oil
The
sample?
delay was mainly due to trying to get the analysis from the lab results for the the point that we knew we had no choice was probably mid-December. And that's when we started filling out our form and doing the check request.
So did you get something in writing saying that, okay, that you had no choice? I mean, saying that the analysis showed metal particles in the oil. And what was that decision point, and when was it, when did you make that decision? Okay, definitely we're not going to operate it, because of the issues with the turbine.
That was just a decision we made based on GE's recommendation not to run it. But there was no email or notification from GE saying, hey, we can't get you samples. You're not going to be up and running anytime soon.
So GE's recommendation, that was November 21.
Right.
So it took a month essentially to file the petition. Why didn't you, while you were getting, you knew the recommendation was not to run it, why didn't you file it shortly thereafter, even after the Thanksgiving holidays? What took so long is the question.
We were still hoping to get lab sample results at that point. And, the lab didn't come back to work until after the holidays. So we thought we'd had samples within a week or at the most a week and a half at that point. But when that didn't happen, was our tipping point. Obviously, even if it was another type of repair, not a pull-out situation, we weren't going to make the January 1st deadline for our emissions testing.
Okay. If the results came back showing, what were you expecting? I mean, from the results? actually, what was the confirmation you needed from the lab results?
whether it was bearing material or not.
And if, let's say it was not bearing material, then you would have operated the turbine?
Then they would have told us, where the material would come from. I would expect GE to know, what material is inside their lube oil pump, right? Change the lube oil pump, which are readily available. Probably a 2-3 day job. Flush the system. System could be flushed, and we likely would have been up and running at that point in early December. We would have scheduled the test and had it completed before the end of the year.
Okay. So when the results came back saying they were particulates in the oil, then you knew there was a serious problem.
We never got results until yesterday.
Oh, you didn't? Okay. Then,
We made the decision to go ahead and file the variance because we weren't getting results, and there was no end in sight to that fight between GE and FAST.
Okay.
And we were, even if the results came back yesterday, right, saying that it's a lube oil pump and not the bearing, we're still outside of compliance because now we're late January.
right. When was that decision actually finally made that, okay, we need to file for a variance? Do you have a specific date?
I don't recall that specific date when we started working on the variance.
Okay. Couple of weeks before the filing, or
It was a couple of weeks before.
it took a while to prepare it and get the
To
check and all
prepare it
that?
and get the check.
Get the check.
The check is,
So once you knew there was a problem, you started the work on
that's
filing?
correct, yeah.
Okay. And that's the part I'm trying to hear, seeing whether you had, one of the finding is, I guess, I think there are 4 findings we have to make for good cause to proceed for the next phase. And clearly in violation because the test was due the end of the year, right? Last year.
That's correct.
So you're in violation of not conducting the test. And the circumstances could not have been avoided. I didn't hear testimony on that, but I'm assuming that you've done regular maintenance on the unit, so you didn't expect this failure of the bearing?
That's correct. That we had an engine borescope in May on that gas turbine, showed no indication of any sort of wear. We had oil samples collected from that gas turbine, and it didn't show any evidence of medical particles, and that was in that second quarter of last year. Again, no indication. So we were doing our routine maintenance, and we had no indication. We never did get a chip detector alarm that tripped us leading up to this. And that's your typical indication that you have bearing particles in your lube oil system.
And the third finding, and I'll read that, is you exercise diligence as soon as feasible after you knew that a variance is needed. So would you say that's what you did?
I believe that that's what we did. At the point that we figured we weren't going to get a quick answer, we went ahead and started the variance process.
And how long does it normally take to get a check in your agency?
It does take anywhere from a week to 2 weeks.
Okay. And then the final one is whether the denial of the variance will either result in emission increase. It's not operating, but so there's no emission increase or.
That's correct. It's inoperable.
Yeah, okay. All right. That's all the question I had. Thank you.
Mr. Pearman?
So kind of trying to restate your position, it seems like GE's recommendation that you note to not operate the unit was uninformed, that they did not have the lab sample results at that point either, correct?
So it's obvious that there was medical particles in the lube oil. You could visually see them. You could manipulate them with a magnet. The question was, what was the composition of those medical particles? And they did not have, or we did not have confirmation at the time. At that point, that's why it was sent to the lab, and we're, trying to figure out what the medical particles were, where they're from, the source of the metal particles.
Okay, so you agree with what I just said?
Yes.
And so you were of the opinion at that point that if results showed it was a certain type of repair needed, that could be done quickly in time to still do the test by the end of December?
That's correct.
Thank you.
Mr. Silva, did you, how long did it take from the time that you informed management to the time that they finally agreed to go ahead, give you a check and try to pay for the resolution of this?
So it took us, I believe about 3 to 4 days to get the check request processed.
Okay, 3 to 4 days, okay. And during that time, you were also in contact with GE? Were you calling them and asking, when was it going to be, that information would be available?
During that time, we continued to talk to GE as well as GE's, what we thought were the competitors for the repair on this gas turbine.
Mm-hmm. And they didn't give you any specific date or estimate, anything at all?
At that time, there was no estimate on when we would get results back, but there was a lot of back and forth on, can we pay fast instead of GE paying fast? And,
I understand, yeah.
We'll fast.
Fast was the third party.
Fast is the third party.
Yeah.
We'll fast accept, credit card, splitting credit card in lieu of upfront payment. That's
And they
much.
declined?
Fast is willing to do it. Obviously, that's against city policy to split charges, circumventing the city's purchasing policy.
Mm-hmm. Okay, any other questions, board members?
Yes. Thank you for your service as the plant manager or the power manager over there in Pasadena. Water and power, just to be very clear, so the turbine is inoperable right now, and are we still on a 1-year plan for it to be fully operational, repaired, et cetera?
We are still waiting for a firm timeline from GE for the repair and get it back up and running. Obviously, they won't know the full scope of the repair until they get it in their shop and get it disassembled. But I expect this to be a 6-month repair project. But we have heard that, like every other industry, there are supply chain issues there that have affected some of their components. And if for whatever reason, that's one of those components is the one that's out, then we're waiting until the supply chain issue is resolved.
Okay, so on your document, number 24, it stated if the regular variance is to extend beyond 1 year, goes on with the verbiage, you list EWP anticipates the unit to be repaired and up and running within 1 year. So you're stating that 6 months is within 1 year. You don't believe it'll go beyond 6 months?
I don't believe it'll go beyond the year, definitely. But my guess it'll be 6 months.
Okay. How many homes does the agency provide power to, roughly? You're providing power to businesses, school district, homes, et cetera, I would assume.
I'm not quite sure how many homes or
There are approximately 142,000 residents. So that includes commercial and residential.
And you're the only power source, I surmise, for that community.
so the city actually has a tie to the Edison system, obviously, and most of our power is imported through there. The plant is a peaker plant. We only run, when the ISO calls on us, or if the import threshold across that Edison tie is too high. Currently, that import threshold is 300 or 280 megawatts. Our all-time peak is 320 megawatts. So there will be some days where the plant will have to run to keep the lights on the west side of town during hot summer months, and peak during the peak hours. But we have 200 megawatts of generation on the site. You subtract the 65 megawatts from GT5, you still have a good amount of power to call on under those situations, if all things are normal, of course.
I'm glad you unpacked that point because that's exactly where I was going, to make sure that we're not impacting power source for the community. So thank you very kindly, sir, for your responses. Much appreciated.
So your service is wheeled in from Edison and you are only called upon when the demand is great and you have to supply the additional amount of electricity into the grid, correct?
That's correct.
Do you know, in reference, because I know that they normally deploy the cleanest generation first, do you know where in that list you are more or less?
So, obviously the list varies from day to
Right.
day. We are one of the last ones called. They're all 4 small units or
Mhm.
5. The 5 of them are small units. GT5 was, our workhorse, but it does get less than 700 hours in a year.
Mhm.
So we're not running often.
Okay, thank you. Any-
Medical, what was the date again on the envelope? December
December 21 is the receive date.
21, okay. All right, thank you. I'm not a medical, can I ask why it wasn't scheduled until today?
We did get it the week of Christmas, as he indicated, and there were many people out on both sides, district staff and them. It took until early January before we got a confirmation of the date that parties, the best known folks could be here to present testimony.
So the delay is not due to them, but it's from the logistics in getting the hearing set.
I'm sorry?
No, I think you answered my question. I don't want to put you on the spot.
I only have one other question on the conditions, number 6.
Well, remember we had the bifurcated.
Yeah, okay. I'll leave that alone then. Right, okay, so we're looking at good cause here. Any other comments or questions from board members? Okay, so we can go ahead and go to closing statement. And if you want to start, sir. Before we do that, are there any members of the public that are online that want to contribute a comment and or testimony?
Currently, there are no members on Zoom with hands raised, and it appears that there are no members in the public to offer testimony or comment in the office.
Thank you. Okay, I don't know there. It's going to be you, Mr. Silva, who's going to present closing statements. And if I can also ask you to go ahead, do you have a copy of the good cause? Of the 4 issues of good cause?
I do not.
You do not. Okay, she just walked out. Because that's what we're looking for. So it would make sense if you made your comments based on the good cause. Teresa, they need a copy of the good cause.
So can I just ask a question? Can he read what he wrote? He wrote good cause on number 4. Would that suffice?
Well, you have to actually, you know how the 6 findings are? Okay, good cause has 4 findings. So we actually have to go through that. And normally, when we have companies that come before us, they either know whether it's the six findings or whether it's good cause, that information, in requesting information regarding those findings, it's normally online. But that's normally what the petitioner needs to um, show to the board that you had, there we go. And also normally we have a timeline, which is normally requested for the hearing, especially when it's an interim hearing, because then the board has a better picture, a better snapshot of exactly what occurred. Because as you heard, we've been kind of going back and forth with the dates. So I'm going to go ahead and give you, is 5 minutes enough for you to read through it and then make your statements around those four issues?
Yes, it is.
Okay, so we're off the record for 5 minutes. Morning break. Let's go ahead and take 15 minutes. So we're off the clock for 15 minutes. record. All right, Mr. Silva, were you able to digest the information on the good cause and to go ahead and make your statements relevant to good cause?
I will.
Okay, you can start, sir.
So to address good cause as the closing, why the variance is needed is obviously the equipment is non-operational. And we are in violation of our Title V permit, Section D, Condition D 29.7. We will not be able to complete our required emissions testing, NH3 slip and RADA, as we were scheduled to do before the end of the quarter. We believe it is reasonable to ask for this hearing without public notice due to the unforeseen nature of the equipment failure, the point at which it happened and the circumstances beyond that to what I've testified as the delays in getting a response for our course of action for the repair. We believe the city acted as expeditiously as the city can act to get the variance filed after that. And at the point at which we knew we had the bearing or had the situation and GE had recommended that we do not place that unit back online, we were already outside the public notice threshold for a hearing before the end of the year, and we would have been in violation on January 1st. We believe that this interim variance grants us relief from January 1st. We will be coming back for a regular hearing that will be public noticed. And this is just to make sure that we're in compliance or we get the variance from compliance for the situation.
Thank you, sir. Ms. Reichert?
Thank you. The district is not opposed to a finding of good cause in this case. Thank you.
Okay.
Madam Chair, if I may.
Oh, yes.
I just wanted to clarify the record. The board members had a question about the customers, and I did find the information. I gave a number for approximate number for residents in the city, but there are 65,000 power accounts and 8,000 of those are commercial. The rest are residential. I just wanted to clarify that.
Thank
in
you.
case that makes
Okay.
any difference.
All right. Does anybody want to start deliberation on this and go through the good cause findings? Mr. Pearman?
Yeah, I think the only one in question is due diligence, but I think that implies reasonableness, and I think it's reasonable that faced with the choice of having to take something out and repair it based on incomplete information, one would wait and see if there's an alternative that's reasonable to see if a lesser repair is appropriate. And they didn't wait an eternity, they waited maybe 2 weeks to see if that could occur. Third-party confusion is part of the problem. And I think after that, they acted timely. So I'd find they satisfy that leg of good cause.
I happen to agree with you. The fact that cities especially have a tough time getting upper management and some cases when it goes to the city council to get all of that approved and get the monies approved. It's quite a process. And especially for a generating station, when you are going after parts like this and you only have that one sole source, it's pretty difficult. The third party, trying to go to the third party, and that didn't work either. So I also find that there was good cause here. Mr. Balagopalan?
Yes, I too can find good cause. I think maybe they should have been a little bit more diligent, but I think when they knew that the bearing is the one that's causing the problem, they knew they cannot restart the turbine, and so they need to get a variance. And they did file to 21st before the end of the year when the test was supposed to be conducted. So unfortunately, and I think because we look at the day, it's today and it's like a month away, but because of scheduling it, I didn't get scheduled earlier. However, I think Mr. Silva is mistaken that it's not retroactive. It will go, it's prospective. The variance will start today. So, I think I can also make the 4 findings for good cause. They're in violation of the permit condition D 29.7. And while they didn't mention the rule, I will indicate the rules 203B 2004 F1 and 3002 C1 that they're in violation of, specifically condition D 29.7. So that's the first. Then second, it was circumstances leading the violation could not have been reasonably avoided. I think, as Mr. Silva pointed out, they did the bore scope testing in May, and the analysis of the oil, there was no indication that this was going to happen. So there was something that they didn't expect will occur. I think we covered, at least I covered the exercise diligence once they knew that they need to get a hearing. They started the paperwork, and the denial of variance will not result in increase in emission because the unit is not in operation right now. It's taken out of service and needs to be repaired. So for all those reasons, I think can find good cause, and we can move to the next phase for the interim variance.
Thank you. Okay, and is that your motion? Are you making a motion on that?
Yeah, I'll make a motion that we, in the matter of, excuse me, City of Pasadena, Department of City of Pasadena Water and Power Department, case number 2244-36, that we find good cause to move to the next phase with the interim variance.
Finally, seconds.
Okay.
And in that second, I would like to also establish for the record that good cause was indeed and has been demonstrated. And I am very thankful that the city did move diligently. It appears that there's a couple areas where this could have arrived a little more timely, did not. But needless to say, the city did in fact move very diligently in their pursuits. And they explained the fact that there were issues with third parties for which they had no control, not the least of which includes just the overall procurement process, which is the case for any municipal and or local government. So I just want to place it on the record.
Thank you, Mr. Ali. Okay, any other comments in reference to the motion? Okay, seeing none, how do you vote, Mr. Ali?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Yeah.
And I also vote aye. It's unanimous, and we can now proceed to the second portion of the hearing, which has to do with the 6 findings. Do you have a copy of the 6 findings, sir?
I do not.
Okay, Madam Clerk, is it on the other side of the sheet that you gave him?
I do have a copy of the 6.
Okay, all right, so this is what we're going to be looking at when we are going to consider whether we are going to approve a interim variance. And we do have an exhibit as Exhibit A as an apple that is coming from the district, and it is the proposed interim variance conditions hearing board case number 2244-36 for the City of Pasadena, DWP, and this is dated as of the 25th, which is today. So with that, let's go through the regular process. Who is here on behalf of the City of Pasadena?
Lisa Hosey, Assistant City Attorney.
And I didn't get the spelling of your last name.
HOS as in Sam, EY.
Thank you.
Thank you.
Excuse me, do we have to go through the
Eh,
process?
Yeah, we do. It won't take long. I won't take long. And on behalf of the district,
Mary Reichert on behalf of the executive officer.
thank you. Okay, and I'm not going to go through the swearing in because we've already done that. So in that case, Mr. Silva, are you going to be making the opening statements based on the 6 findings?
Yes, I will.
Okay.
So the city has established that we have equipment failure to one of our gas turbines. We will not be able to perform the required emissions testing before the end of the year until the gas turbine is repaired and back online, so we can place the unit online and have the emissions testing company come out and verify our emissions, both for NH3 slip and RADA. The breakdown to the gas turbine was outside of our control and unexpected, of course. We have been performing our due diligence as far as maintenance on the piece of equipment. We did have a bore scope performed in May and oil samples collected and analyzed in the second quarter of the year that both came back clean without any indication that we had a pending bearing problem. The unit obviously is not online, and it does serve the public. We are a municipality. The gas turbine is essential local generation, especially during hot summer months when the ISO capacity is constrained or the import capacity into the city of Pasadena is also constrained due to the infrastructure. So for hot summer months, we do bring local generation on to cover the difference between what we can import and the low demand from the citizens of Pasadena. Gas turbine 5 is our most efficient unit and actually the one with the largest capacity as well out of the fleet for the local generation. In this case, we cannot curtail operations. The operation of the unit is already at 0 as a result of the suspected bearing failure. So there will be no excess emissions during the variance period. We will continue to operate the SIMs, continue to do QA. So the monitoring equipment is not impacted and it'll continue to measure emissions, and we will have valid zeros through the variance period that'll indicate that the unit is not operating during the variance period. That's it.
Okay, thank you. Ms. Reichert.
No, yeah, yes. It's not lighting up. Subject to the testimony presented here today in compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Thank you. Okay, are there any members of the public, Madam Clerk? Is she there? Okay.
It's not a notice hearing, so, but
There's no members of the public that want to make a statement or provide testimony?
There's no members with their hands raised and that are online. And there appears to be no members in the public that have submitted cards or that want to present testimony or comments in person.
Thank you. Okay. Were you going to make a statement, Mr. Pearman?
Could you ask the petitioner if they agree to the proposed interim variance conditions on Exhibit A so that we know if it's stipulated or not?
We do agree to the proposed conditions on the interim variance.
Thank you. Any other comments or questions from the board?
They, I mean, before we get there, I think they're not going to produce any additional witness, but I think we need to go through that process before we go to the
Okay,
the closing statements and so forth until, and then before we deliberate.
Questions for the witness.
right,
I think that was his testimony, not.
right, and he's their only witness.
Oh, that, not just the opening, okay. In that case, Mr. Silva, if you condition, the proposed condition, specifically condition number 5, have you looked at that? And specifically, I think you mentioned you will continue to operate the SIM. There's language actually that I proposed in some previous case. The last sentence there, in lieu of the above mentioned requiring the petitioner may choose to comply with the requirements in 2012 C2D and 2012 C2E as amended on November 3rd. It should say 2023. That's a mistake that's been cascading in several of the cases, but it should read 2023. But I wanted to bring your attention. Are you aware of there was an amendment to the rule that gives you another option instead of running the SEMS to do other requirements, so you don't have to run the SEMS if you meet the requirements that is set in the rule?
I was not aware of the alternate solution to running the SIMs. To me, you keep your equipment running until you can't, and keeping your SIMs on is always easier than shutting it down and then restarting it back up.
Okay. But you are open to looking at that?
We certainly will look at that.
That's it. So in condition 6, I think it says to pay the fees. There are no excess emission at this time, so there's no fees to be paid, correct? We don't anticipate paying any fees.
That's what we anticipate, right?
Yeah. Okay, I've no further questions.
Any other questions? I think we already went through the type of system and equipment that you have and who you serve, and that the fact that you're a peaker plant and not base load, and that you wheel in your electricity through Edison, and that the fact that this one unit is going to be down is not going to affect your ability to respond to the ISO, I believe, to be able to produce when you have that demand and that you're called upon to be deployed. So I think we already went through all of that, and understand that in this case, it was not anything that was you anticipated or that was your fault, and you have done your best to try and get GE and a third party even involved in this to try to repair and get the unit back online. So from all of the information that we received going through the good cause will be moved into also evidence for the 6 findings as well. So with that, I don't have any questions and or statement. Any board members have any other comments or statements? Okay, so with that, we can go ahead and go to a closing statement from you, Mr. Silva.
So in closing, it is an unfortunate situation that the city finds itself in. It doesn't appear that it's going to be an inexpensive repair on the gas turbine, but the city is committed to providing its citizens with a safe, reliable, and efficient source of electricity. The local generation facility plays a large role in making sure that we keep the lights on. The Department of Water and Power has an exemplary outage rate and outage response time, and that is in large part to having local generation. this situation obviously was unforeseen, and the city believes we acted diligently to get our variance filed, and get ourselves into compliance. We'll get this gas turbine repaired, and as soon as we can, possibly get that repaired, put it back in service. And then as the conditions of the variance dictate, we will complete the emissions testing and be back in compliance with our permit.
Thank you. Okay. All right, Ms. Reichert?
Thank you. Subject to compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Thank you. Okay, based on all of the information that we have heard from Mr. Silva, as well as the willingness to comply with the 6 findings, I'm sorry, with the conditions, the 7 conditions actually, I feel that we can go ahead and grant the interim variance. Any other comments or statements?
Yes, just one, number 6. What is the date that will be inserted into this section?
Well, there's no fees because there's going to be no excess emissions,
Okay,
correct?
okay.
All right,
Just
so
one. All right.
can we just delete number 6?
Yes.
Okay, let's delete number 6 and number 7 will become number 6. Okay. Anything else, board members? Any other comments or questions? Mr. Bell, come on.
I'll be happy to make the 6 finding and make the motion.
Okay,
So, I'll just go through the 6 findings again. They are in violation of permit condition D 29.7. So specifically rule 203B, because you're Title V and reclaim facility. So it's 2004 F1, again, condition D 29.7 and 3002 C1, D 29.7 permit condition D 29.7. So they're in violation of those 3 rules, and the non-compliance of the rule is beyond the reasonable control, as we heard. And so the failure of the bearing was not anticipated. The closing of taking would be without a corresponding benefit. There's no in reducing a contaminant, they're not operating, so there's really no impact there. So the harm to the petitioner outweighs the benefit they are calling this situation because there's no emission associated with it. The petitioner has, well, in the next 4, 5, 6, because they don't have to do any curtailment because it's already offline. So it's not, there's no excessive emission during this period. And they're not, even though they'll have the SEM, so they plan to run the SEM. So alternatively, Mr. Silva say, look at the condition number 5 and see if that's something they want to pursue. Yeah, so all the 6 can be made, and I'll go ahead and make the motion that to grant the interim variance. And let me get my. So in the matter of City of Pasadena Water and Power Department case number 2244-36, I move that we grant an interim variance commencing today and continuing for 90 days or until ending in 90 days or until a notice for regular until a notice hearing for regular variance currently scheduled for 2/29/24 occurs, whichever occurs first, from the rules and subsection that I mentioned for the equipment, which is the gas turbine and the associated control that is listed. So it's D56, C67, and C66 of the for the gas turbine, selective catalytic reduction, and the CO oxidation catalyst, all associated with the gas turbine. For the equipment located at 72 East Glen Arm Street in Pasadena, California 91105, and the conditions are as listed in Exhibit A, with the change that the in condition number 5 that it should read 2023 instead of 2022 at the very end, and the removal of condition number 6 and the renumbering of the condition 7 to 6.
Second.
Just one thing, Mr. Balgobin, I don't know whether I heard you say that on that last line of number 5, that the date should be November 3rd, 2023.
23. It's not 2022.
Right, okay. And with that, we have the second. Is there any-
And I'm sorry, and there are no excess emissions.
Correct. Any discussion on the motion? Oh, if not, then let's go ahead and vote. Mr. Ali,
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan.
Yes.
And I, and thank you very much for your due diligence. And you have a unique situation there that you've got to work with that third party and try to get everything back in line. So, and it's thank you also for the engineers from the district for working with them. So,
Madam Chair, not related to this matter, I just had a brief procedural note I wanted to make.
okay.
So that's okay. I just was looking at the hearing board rules, and hearing board rule 4B1 did notes that relating to consent calendar items, that consent calendar items should be heard at the end of the calendar unless there's members of the public that are present for those matters. And I did note that you had taken the consent calendar items first. It's not a problem today. We were totally fine with it, but in case there are matters that maybe there's a time frame for the witnesses and things like that, I just wanted to note that the rules do state that the matters that are not on consent should be taken ahead of the consent calendar items unless there are members of the public for the consent calendar.
Okay, duly noted, because we follow the agenda.
Yeah.
And I'm sure that if it's in the rule 4B1 that we should be following
Yeah.
it correctly and put the consent items last.
Yeah. So I just wanted to make a note of that. And I know that you always want to make sure that the public has a chance. So there is that provision in there as well. So I just wanted to make a note for the board's consideration.
Thank you so much.
Thank you.
Okay. All right, thank you very much for attending, as well as my board members. Thank you very much for all the comments today. And so with that, we are adjourned.